With the permission of the Honorable Chief Justice, I now request Mr. Mansoor Usman Awan, Attorney General for Pakistan, to address the court.
Mr. Justice Qazi Faez, Honorable Chief Justice of Pakistan, Mr. Justice Yahya Afridi, Honorable Chief Justice Designate, Honorable Judges of the Supreme Court, Mr. Farooq H. Naik, Vice Chairman, Pakistan Bar Council, Mr. Muhammad Shahzad Shaukat, President, Supreme Court Bar Association, worthy members of the Bar, ladies and gentlemen. We are gathered here today to celebrate the outgoing Chief Justice Isa's completion of an illustrious judicial career spanning over 15 years. Throughout his career, Chief Justice Isa has demonstrated an unwavering commitment to constitutionalism, rule of law, democracy, and accountability. Chief Justice Isa's judicial career began rather uniquely when he was directly appointed as the Chief Justice of the Balochistan High Court. Prior to his appointment, he had securely established himself as one of the most prominent and successful litigating lawyers in the country. His commitment to public interest stood out during his 2.5 decades at the bar. In a landmark case titled Balochistan Bar Association versus Government of Balochistan, PLD 1991, Quetta 7, the young barrister Qazi Faez represented the Balochistan Bar Association to successfully challenge the Criminal Law Special Provisions Ordinance 1968. In another case titled Begum Said Qazi versus Quetta Municipal Corporation, PLD 1997, Quetta 1, Barrister Isa represented himself and his family, resulting in the Balochistan High Court directing strict compliance with the building code in the area under the jurisdiction of Quetta Municipal Corporation. During his tenure as the Chief Justice of Balochistan High Court, Chief Justice Isa rendered several notable judgments. In Muhammad Salim Khan versus Government of Pakistan, PLD 2013, Balochistan 10, for example, he upheld the prohibition on state-funded Hajj for government officials. In Nasreen Khetrani versus Government of Balochistan, PLD 2012, Balochistan 214, Chief Justice Isa emphasized the importance of the fundamental right to information under Article 19A of the Constitution and consequently directed the respondents to ensure the operation of all schools in the province and to further ensure that teachers attend schools to impart education through proper and periodical monitoring by the district education officers. In Ikramullah versus the State, PLD 2012, Balochistan 16, Chief Justice Isa demonstrated his commitment to environment by emphasizing the importance of protection of wildlife in Islamic tradition. In Gira Naz versus the State, PLD 2010, Quetta 61, and Ata Muhammad versus the State, 2010, YLR 3000, Chief Justice Isa upheld women's right to marry out of their own free will. After a 5-year tenure as the Chief Justice of Balochistan High Court, Chief Justice Qazi Faez was appointed to this apex court where he has served for a decade. During this leg of his judicial career, Justice Isa continued to serve the cause he had championed at the Balochistan High Court. In Shah Zaman Khan versus Government of Khyber Pakhtunkhwa and Province of Sindh versus Lal Khan Chandio, Justice Isa once again highlighted the human burden to care for the natural environment, drawing strength from Islamic sources, among others. Similarly, in a number of judgments including Muhammad Rafiq versus Ghulam Zora Mai, Laila Qayyum versus Fawad Qayyum, and Munir Hussain versus Rifat Shamim, Justice Isa protected the women's right of inheritance. In the famous Faizabad Dharna judgment, Justice Isa dilated upon the right to assembly and protest and the reasonable restrictions that may be imposed thereon. Importantly, Justice Isa noted that the right to protest is circumscribed only to the extent that it infringes on the fundamental rights of others, including their right to free movement and to hold and enjoy property. Justice Isa further held that intelligence agencies must operate within their mandate, and any transgressions into the realm of politics by these agencies must be held accountable. In September last year, Chief Justice Isa took oath as the Chief Justice of Pakistan. Since then, Chief Justice Isa has exhibited extraordinary judicial leadership. Upon taking office, Chief Justice Isa called a full court meeting after a long hiatus. Under his leadership, the Supreme Court collectively decided to live stream proceedings in cases of public importance, promoting transparency and accessibility for the masses. On the judicial side, Chief Justice Issa, without wasting time, upheld the constitutionality of the Supreme Court Practice and Procedure Act 2023. In doing so, this court approved Parliament's decision to abolish the Chief Justice's absolute power to constitute benches and fix cases. This was a pivotal moment in our judicial history, and Chief Justice Issa's role in ensuring greater accountability and transparency within the judicial branch cannot be overemphasized. Another important contribution by Chief Justice Issa is his role in the conduct of general elections held on February 8, 2024. This court, under the leadership of the Chief Justice, paved the way for all stakeholders to agree on the set date for the conduct of general elections. This ensured that our country continues to tread the democratic path. There was yet another hurdle when the Lahore High Court, through order dated December 13, 2023, in writ petition 8083 of 2023, suspended notifications issued by the Election Commission of Pakistan, whereunder district returning officers and assistant returning officers were appointed. Had the suspension order of the Lahore High Court been allowed to hold the field, the general elections on February 8, 2024 would have been a virtual impossibility. Chief Justice Issa, without any delay, on 15 December 2023, suspended the Lahore High Court order and cleared the path to the general elections which were held, and our democracy was once again saved. In a nascent democracy like ours, the role of the apex judiciary is not only to preserve democratic values, but more often than not, it is to actively shield it from ever-evolving challenges. In his tenure, Chief Justice Issa saw democracy through a particularly turbulent time. Throughout his time on the bench, Justice Issa has promoted democracy, transparency, and accountability, not only generally, but also for himself and his own institution. I can say without hesitation, on the occasion of his retirement from bench, that his father, the late Qazi Muhammad Issa, one of the founding fathers of our country, would be proud. We wish him a happy retirement and hope that he will continue to serve democracy, rule of law, and constitutionalism post-retirement. Thank you very much.
Thank you, Attorney General. Now I request Mr. Farooq Hamid Naik, Vice Chairman, Pakistan Bar Council, to deliver his speech.
Bismillahir-Rahmanir-Rahim. Honorable Chief Justice of Pakistan, Justice Qazi Faez Issa, Honorable Justice Yahya Afridi, Chief Justice Designate, Honorable Judges of the Supreme Court, Mr. Mansoor Usman Awan, Attorney General for Pakistan, Mr. Shehzad Shaukat, President, Supreme Court Bar Association, distinguished members of the Bar Councils and Bar Associations, ladies and gentlemen, Assalamu alaikum. It is both an honor and a privilege to stand before you today as we gather to bid farewell to an individual whose career exemplifies principles of justice, integrity, and judicial independence. Today's ceremony not only marks conclusion of Justice Qazi Faez Issa's tenure as Chief Justice of Pakistan, but also reflects continuity of a tradition that strengthens our judiciary and reinforces its vital role in democratic fabric of our nation. This gathering is a moment to reflect not just on remarkable contributions of Justice Qazi Issa, but also on the journey of our judiciary as a whole. Supreme Court stands as one of the three pillars that uphold the state alongside Parliament and Executive. The trichotomy of power ensures the rule of law remains at the heart of governance, safeguarding rights of people and sanctity of our Constitution. Since the birth of Pakistan, judiciary has played a crucial role in defining justice and governance. As one of the three pillars of state, alongside Parliament and Executive, it is entrusted with interpreting Constitution, protecting rights, and maintaining balance of power. Judiciary has evolved over time, adapting to societal changes while safeguarding rule of law. In its early years, judiciary worked within a legal framework inherited from colonial rule, gradually asserting its independence. Landmark decisions shaped democratic norms, though political pressures and executive overreach occasionally tested its autonomy. Yet, through these challenges, courts emerged stronger, ensuring civil liberties and justice in times of uncertainty. Independence of judiciary is the principle that judiciary should be free from outside interference and be able to make decisions fairly and impartially. This means judges should not be influenced by other branches of government, private interests, or partisan groups. Independence of judiciary is important because judges often decide matters between citizens and state or between state and powers of entities. In Pakistan, Article 2A of 1973 Constitution states that independence of judiciary should be fully secured. In Sharaf Faridi's case, Supreme Court explained that it is a duty of every judge to decide matters in conformity of facts and his understanding towards law without any influence and pressure. An independent judiciary is vital to protection of human rights. It is absolutely essential to resist undue influence and provide remedies for justice problems. Judiciary in Pakistan must provide an expeditious and inexpensive remedy in matters relating to ordinary litigants as well as matters relating to infringement of fundamental rights. Independence of Pakistan judiciary has changed over times, where judiciary used to defer to Pakistan's military by legitimizing martial laws and military dictators who were dominant actors in Pakistan politics. First Constitution of Pakistan, as passed by the Constituent Assembly, was framed in the year 1956, and preamble of the objective resolution could be termed as the grand norm of Constitution of Pakistan, which is incorporated, securing federalism, parliamentary form of government, independence of judiciary, and social welfare state. Objective resolution, which was passed in the year 1949, became part of substantive constitution by incorporating Article 2A in the year 1985. Unfortunately, our military dictators did not allow Constitution of 1956 to function and abrogated the same in the year 1958, and that very insurgency derailed democratic system in Pakistan. This unlawful act of the military dictator was unfortunately upheld by Supreme Court of Pakistan in Dawson's case, reported as PLD 1958 Supreme Court 533. Another constitution was framed in the year 1962, which too was abrogated by another dictator in the year 1969 through an unlawful and unconstitutional act, where elections were held and democratic government came into being in 1971, in which Shahid Zulfikar Ali Bhutto became Prime Minister, who promulgated Constitution of 1973, fully based upon democratic principles as well as based on other clauses contained in previous constitutions. This constitution was smoothly functioning, but however, another dictator abrogated in the year 1977 and remained in power for more than a decade. Once again, Supreme Court upheld such abrogation in Begum Nusrat Bhutto's case. In Government of India Act 1935, there was no specific provision about persons who have to be consulted before appointment as federal court judges. According to Act 1935, they were appointed by His Majesty by warrant under Royal Sign Manual, and they could hold office until age of 65 years. Constitution of 1956 provided that Chief Justice of Pakistan shall be appointed by President and other judges shall be appointed by President after consultation with the Chief Justice. With regard to the appointment of High Court judges, under Constitution of 1956 it was laid down that every judge shall be appointed by President after consultation with Chief Justice of Pakistan, Provincial Governor, to which appointment related, and if appointment is not that of Chief Justice of High Court. Constitution of Pakistan 1962 provided that Chief Justice of Pakistan shall be appointed by President and other judges shall be appointed by President after consultation with Chief Justice, whereas Constitution of 1962 provided that High Court judge shall be appointed by President after consultation with Chief Justice of Pakistan, Governor of province concerned, and Chief Justice concerned, where appointment is not at that of Chief Justice. Since 1973, judicial system of Pakistan is being regulated under Article 175 of Constitution, which provides for establishment of Supreme Court and High Courts in each of the 4 provinces. Through an amendment to this article, High Court for Islamabad has also been established. Induction of High Court judges earlier was made on recommendations of respective Chief Justices after approval of Provincial Governor concerned. Thereafter, matter was sent to Chief Justice of Pakistan and accordingly final approval was made by President through Federal Ministry of Law. This procedure was completely changed through 18th Amendment in Constitution of Pakistan by adding Article 175A, which provided for Judicial Commission comprising of judges of Supreme Court and High Courts, Federal Minister for Law and Justice, Attorney General for Pakistan, and representative nominee of Pakistan Bar Council and Provincial Bar Council. After nomination was made by Judicial Commission, matters were referred to Parliamentary Committee, consisting of 4 members from Senate of Pakistan and 4 members from National Assembly. And out of these 8 members, 4 were to be taken from Treasury benches and 4 from opposition. Committee had power either to confirm nomination made by the Judicial Commission by majority of its total membership or may not confirm nomination by 3/4 of its total membership. Now, 26th Amendment to Constitution has been promulgated, which has merged Commission and Parliamentary Committee. However, under 26th Amendment, a woman or a non-Muslim other than Member of Parliament who is qualified to be a Member of Senate as a technocrat has been added in Judicial Commission. The role of civil society has been given. After promulgation of 26th Amendment, independence of judiciary is not infringed. Independence of judiciary is obvious from the fact that tenure is fixed and a judge cannot be removed except on grounds as mentioned in Article 209 of Constitution by Supreme Judicial Council comprising of judges of Supreme Court and High Court. Similarly is the case for removal of punishment of members of armed forces by courts established under the Pakistan Army Act 1952, and that also speaks about independence of institution of army. However, independence of parliamentarians is not secured. In case of inappropriate action by them, their removal or punishment is not by their own brother parliamentarians, but by judges. It is a historical fact that on false allegations which have been leveled against parliamentarians have led to the removal by judges of the past, and even governments were dismissed, and 2 prime ministers were removed through judgments of Supreme Court of Pakistan. Let us look into the mode of appointment of judges in superior courts in few other countries. In USA, justices of Supreme Court, Court of Appeal judges, and District Court judges are nominated by President and confirmed by US Senate. In Canada, justices of Supreme Court of Canada are appointed on Prime Minister's advice, and judges of provincial and territorial courts of appeal are appointed by provincial and territorial governments through judicial advisory committees, which are appointed by provincial and territorial government, in which there are nominees of government. In United Kingdom, there is a selection committee for selection process convened by the Lord Chancellor consisting of 5 members. In Australia, executive enjoys unfettered powers of judicial appointment. So, a Chief Justice holds a unique position in this evolution, not only for just interpreting laws, but also guiding judiciary through internal reforms and external pressures. Over years, each Chief Justice has left a distinct legacy, some reinforcing independence and others setting new constitutional precedents. Justice Qazi Faez's tenure as Chief Justice demonstrated an unwavering commitment to transparency, judicial restraint, and rule of law. His leadership exemplified a careful balance of authority, contributing significantly to strengthening democratic principles and environmental governance. One hallmark of his tenure was his minimal use of suo motu powers, in stark contrast to his predecessors, who took dozens of such notices, on one with 64 and another with 57. Justice Issa used his power sparingly, reflecting his philosophy of judicial restraint and rejection of judicial activism, which he saw as critical to maintaining institutional balance. He was also a vocal opponent of judicial martial law, reinforcing judiciary's role in supporting democratic governance rather than intervening politically. Justice Issa rectified major unconstitutional decisions, such as overturning lifetime disqualification of politicians under Article 62(1)(f) and addressing misinterpretations in Punjab government case related to Article 63A. His correction of historical wrongs also included revisiting Zulfikar Ali Bhutto's Shahid's case, restoring dignity of judiciary and rectifying past injustices. Another important achievement was his handling of election-related matters. Justice Issa before elections are held on schedule, despite obstacles. His rulings compelled institutions to act according to law, preventing undue delay through judicial intervention. Supreme Court, under Chief Justice Qazi Faez Isa, formally resolved controversial dam fund issue by distancing judiciary from the project. Justice Isa ruled that responsibility for the project lies with the executive, while management of funds belongs with the State Bank of Pakistan. Court ordered transfer of collected funds, around PKR 23.67 billion, to public accounts of the Federation, ensuring transparency and proper state oversight. In environmental governance, his leadership was evident in rulings like Monal restaurant closure, where he underscored constitutional right to a clean environment. He framed environmental protection as essential to human dignity and ordered restoration of Margala Hills National Park with minimal disruption to wildlife. Justice Isa also presided over Faizabad Dharna case, which held various state agencies accountable for overstepping their roles. This bold decision reaffirmed the principle that armed forces and intelligence agencies must adhere to their constitutional mandates and avoid political interference. Through these contributions, Justice Isa has shown his ability to lead without overstepping his authority. He delegated powers to committee, avoided unnecessary administrative interference, and declined official protocol, ensuring that his tenure was marked by humility and fairness. His refusal to seek a tenure extension further exemplified his commitment to institutional dignity and principle that public office must be held in trust, not entitlement. And how can we forget Memo Gates, sir? Justice Isa's legacy lies not only in his judgment, but in his broader efforts to nurture judicial independence, promote transparency, and promote democracy. His tenure serves as a benchmark for future judicial leadership, inspiring a balanced approach towards justice and governance. A strong judiciary